Officer Day, would you open my courtroom, please?
The State of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson, Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor. Good
morning. We are on the record on a motion for summary disposition. This is case number 201517974, Integra Lab Solutions versus City of Detroit. Could I have your respective appearances?
Joe DeCrube on behalf of the plaintiff, Your Honor.
Okay, let's do it one at a time.
I apologize.
All right.
Patricia Porter on behalf of the city, P66989.
Mr. DeCrube.
Joe DeCrube on behalf of the plaintiff, P8484445.
How many numbers do you have?
I'm a newbie, Your Honor.
Write it down. You ought to be able to, you got it, because you're going to need it. People are always going to ask it, okay?
Yes, Your Honor.
Even when we go live, when you show up in courtroom live, the court reporter is going to ask you for your bar number. Okay.
Yes, Your Honor.
I don't have an answer for you, sir. Did you file an answer to the motion for summary disposition?
Yes, Your Honor. We have a response that was filed. It was filed on February 1st. So I from what I see in our record, so it might have not.
Well, the courtroom says you have to have it 7 days before the hearing. And today is February 5th. So if you served on February 1st, by definition, it's not timely. Let's hear from Ms. Porter.
Thank you, Your Honor.
Did you get that response?
Yes, I did.
Everybody got it but me. Okay, let's go ahead.
Okay, the facts are undisputed because it's the date of the accident, 8/7/17, and the date the complaint was filed, May 12th, 2020, under MCL 500-3145-1. There's a statute of limitations 1 year from the date of the accident. So this complaint was not filed until almost 3 years later, and it's barred by the statute of limitations, which ran on August 7th, 2018.
Okay,
Our second.
Let me stop you there. Had you paid anything
Sure.
to Integra Labs in that interim between August 8th, 2017 and August 8th of 2018?
I don't believe we have. I did not check my file notes on that. I don't believe, but I'm not sure. I'm sorry.
Because the statute says 1 year unless a payment has been made or written notice has been given.
You're correct, Your Honor, and I can check on that, but I do have a second argument that I believe bars the complaint on its own in addition to the statute of limitations in subsection 1, and that is the limitations on damages provision in section 500-31-5 sub 2. And that says you can't recover any damages more than 1 year before the complaint was filed. Yes, and this date of service was undisputedly in April on the 22nd, 2019, more than 1 year before the complaint was filed. So on that basis alone, and the defendants did make, the plaintiff did make a tolling argument in the response by just simply attaching the Supreme Court order saying that COVID state of emergency tolled. Yeah, but that happened after. That was in March. That was after both the limitations period ended and after the statute ran. So that tolling argument doesn't help them. And they don't apply it to the case. They just attack.
I don't understand this part of your argument about when did the tolling provision start under the administrative order? That was March.
It started March, correct. March 10th, 2020.
And that would be less than a year from April 22nd of 2019, would it not?
The 1 year limit goes back 1 year before the complaint was filed. So the complaint was filed in May 2020. It goes back for, you can recover for damages incurred from May 12th, 2019. But the date of service was before that, April 2019. That's all before the 2020 tolling.
Let me hear from Mr. DeCrube.
Your Honor,
All right.
I was I'm a little perplexed, and again, I'm a newbie, so forgive me. Sister Counsel might have forgotten more than I'll ever know at this point. But I do want to say this. First of all, as to the first argument, as Your Honor stated on the record, it's either a statutory notice, which is a notice given that there was an injury made, or a payout, and it doesn't have to be to Integra, it can be to anybody, as long as they had the notice.
No,
If I read, okay,
let me ask you this. In relationship to the first argument, the 1 year from the date of the accident, or unless written notice had been given to the insurer, or unless the insurer previously made a payment for, when did Integra first correspond with the city of Detroit concerning this accident?
Your Honor, I would venture to guess, and it would only be a guess at this point, is when the HICFAs were turned in for payment, which would have been on, if you allow me 1 second, Your Honor.
By definition, it would have to be after April 22nd, the date of 2019, the date of service.
Correct, Your Honor.
Okay, continue, sir.
Okay, so as to the first argument, I'll set that aside. As to the second argument, the tolling provision started in March. We had until March of 2020, Your Honor, was when the tolling requirements was put in by the Supreme Court. I'm sorry?
That was to the administrative order?
Correct, Your Honor.
And what did that order speak to?
It spoke to the COVID. It was a COVID related tolling that the Michigan Supreme Court adopted
for filing in court.
I apologize, Your Honor.
For filings in court.
Correct, Your Honor.
Well, where is your authority for the provision for your argument, which is that the tolling of the requirement to file in court affected the 1 year back requirement in relationship to notice to the insurer? You're trying to conflate two separate arguments.
No, Your Honor, both the plaintiff and the defendant at this hearing right now cannot give you a definitive answer as to the first argument. They don't know when they had notice, as Ms. Porter said on the record, and I don't have it in my relation. However, I do agree.
Let me stop you right here. You, by definition, on behalf of your client, could not have given notice to the city under the first argument of 531.45 within 1 year of the accident. There's no argument.
Correct, Your Honor. It's impossible. Correct.
All right, let's confine ourselves to your argument, sir. The second argument is your claim that the administrative order, which told filing of deadlines in court, somehow also applies to your situation. Two separate issues. So
correct, Your Honor. So my tolling argument would not go to the first argument.
Okay.
That one we would lose if the notice was not given, which it couldn't have. If Your Honor is reading it correctly, which again I would go with you, Your Honor, as how you were reading it as opposed to me. However, on the second argument,
let's read the rest of the argument. The notice of injury from 3145 required by this subsection may be given to the insurer or any of its authorized agents by a person claiming to be entitled to benefits thereof or by someone on his behalf. It's quite clear. Let's move on to your second argument, sir.
So, well, if the first argument is defeated, Your Honor, then the second argument would be moot at this point. However, the filing deadline would have been extended past the March date because March is when the Supreme Court took applied the administrative order that would have told. So even if we were not 1 year back of the date of the service provided, okay, it would still have been told past the April deadline, which would have been April 2020, and we filed in May. But because this administrative action took into effect in March, so that would have been told from the date of service. But again, if the first argument is moot, then the second argument loses on its face anyway.
Yeah. All right, this is the ruling of the court. Ms. Clark, what did you want to tell me?
I just wanted to say that we did cite 2 Supreme Court decisions that say that tolling doesn't apply to the subsection 2 limitation on damages. It's not a statute of limitations, it's a limit.
Yeah, I mean, the Supreme Court has already ruled on that, haven't they, Mr. DeCruz?
Your Honor, as to the notice given, the way I read it, Your Honor, is different than the way that you're reading it, which is completely fine. I read it as in if the underlying patient has given notice of the injury, or that they had notice of the injury, that defeats the 1 year requirement to put them on notice of the injury. It didn't have to be integra. But again, Your Honor, I default to you as to your decision.
Well, okay, thanks. This is the court's ruling. In relationship to the argument of 531.45, this is a matter of statutory interpretation. And the statute is clear and unambiguous. 3145(1) says an accident to recovery of personal protection benefits payable under this chapter may not be commenced later than 1 year after the date of the accident causing the injury, unless written notice of injury as provided herein, that is in 3541, has been given to the insurer with 1 year after the accident, or unless the insurer has previously made payment for personal protection for the injury. The statute goes on to say the notice of injury required by this subsection may be given to the insurer or any of its authorized agents by a person claiming to be entitled to benefits or by someone on his behalf. There's really no language, no room for interpretation. The language speaks to the commencement of a filing of a litigation on behalf of someone or someone claiming on his behalf, like you, within 1 year. It's clear, there's no argument on it. That's a matter of statutory interpretation, and court finds that the plaintiff did not meet that 1 year back rule based upon the clear language of 3145(1). Further, the Supreme Court has already spoken on the question of whether or not 3145(2), which is not a statute of limitations, but instead a cap on the amount of recovery. Separate concept. Statute of limitations, commencement of the litigation. Cap on recovery, irregardless of the litigation having been commenced, cannot recover beyond this date. So for both of those grounds, the court finds there's no genuine issue of material fact here. Defendant City of Detroit's motion for summary disposition is granted. Anyone who disagrees with my decision, of course, has an absolute right to appeal. That appeal must be perfected in 21 days of today in the Wayne County Circuit Court. The court will send out an order granting the city's motion for summary disposition. Thank you both for coming in. And we're off the record, and please be safe.
Thank you, Your Honor. Have a good afternoon.
You too, Your Honor.
Have a great day.
You too.
Mr. Taylor, how can I help you? Mr. Taylor?
Yes, sir. Good morning. I think I'm a little early.
Yes, sir. You're not here until 11 o'clock.
o'clock.
And my understanding is someone called indicating that this case had in fact been settled.
Yes.
Is that your understanding?
Yes. Yeah. The lawyer for the plaintiff called me earlier today, and we settled on, I think it was $1,250 with 2 payments to be made, one at the end of February and then the other one within 30 days.
Okay, then it will not be necessary for you to hang around until 11 o'clock. I'll be getting something in writing from the other side, and that will be enough to me to close the file out. And then you gentlemen, after you get your paperwork done, the lawyer will send me the original paperwork, and that'll be done after your payments have been made.
Okay.
Have a great day.
All right, sir. You too. I appreciate it. Stay safe.
Have a good day. Be safe. This is now the conclusion of today's docket. We're off the record.